Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to look at Bill S-203, which is titled An Act to Restrict Young Persons' Online Access to Sexually Explicit Material. Now, lots of things about that title make me a little nervous because young persons, sexually explicit. This sounds like a bill aimed around the "won't somebody please think of the children" kind of angle. And that tends to be how governments sneak in things that people would otherwise object to, like surveillance or censorship. So let's have a look at this bill and see if it's got anything that we should be concerned about. So I'm going to start with the preamble. The preamble doesn't have much legal effect. However, it can be useful to a judge who needs to interpret an unclear provision and determine what the legislature actually intended. However, usually the preamble is there just to sort of provide a justification. This is why we think this is a necessary or important bill. So, preamble. Whereas sexually explicit material, including demeaning material and material depicting sexual violence, can be easily accessed on the internet by young persons. Whereas a significant proportion of the sexually explicit material accessed online is made available on the internet for commercial purposes and is not protected by any effective age verification method. Now, I suspect that commercial purposes, they're including any site that gets ad revenue, which is basically everything on the internet. So that's not a terribly useful phrase there. Whereas the consumption of sexually explicit material by young persons is associated with a range of serious harms, including the development of pornography addiction, the reinforcement of gender stereotypes, and the development of attitudes favorable to harassment and violence, including sexual harassment and sexual violence, particularly against women. Now, this is a scientific statement, and the science is far from clear on this. There's actually a substantial number of studies that suggest that it might be the opposite. Really, we can't say we understand what the effects of viewing porn are on anybody. Now, in terms of pornography addiction, that's something that's very hotly debated. It doesn't actually seem to meet the criteria for an addiction. So a lot of people have suggested that pornography addiction is quite possibly BS. We'll have to see. I'm not a scientist on this, so I can only sort of comment on the general trends, but this is concerning. If you want the Senate to do science, you're going to be disappointed. So whereas Parliament recognizes that the harmful effect of the increasing accessibility of sexually explicit material online for young persons is an important public health and public safety concern, although all of the offenses that they're talking about here are actually going down. So it seems to me that if this was actually causing all the stuff that they're talking about, we'd be seeing society moving in the other direction, right? So whereas online age verification technology is increasingly sophisticated and can now effectively ascertain the age of users without breaching their privacy rights, okay, that is just high-octane bullshit. There is no way that they can ascertain the age of users without breaching their privacy rights. You know, it's got to be some sort of age verification tied to some sort of connection to you. So that there is no way that that actually flies. And whereas anyone making sexually explicit material available on the internet for commercial purposes has a responsibility to ensure that it is not accessed by young persons, really, shouldn't that responsibility maybe be with parents? I mean, there's always going to be bad things online. Parents have to, watch their kids. The government is a terrible parent and really shouldn't try to be a parent. So let's have a look here as to what they're doing here. So short title, we'll skip over that. Definitions. I always want to look at definitions. I know it's a boring section, but definitions tend to be incredibly important when you're looking at law because a change in a definition can affect how a bill works quite dramatically. So internet service provider means a person, and a person can include a corporation. Corporations are persons under the law. That's its own sort of complicated issue. But a person who provides internet access, internet content hosting, or electronic mail. So this is actually substantially broader than most people think, because providing internet access, well, I mean, does that just affect an ISP, or does that also affect, say, a Starbucks that has open Wi-Fi? Does that affect a library that might have, internet that you can connect to? This, does this affect Gmail because they provide electronic mail? All of this is going to be complicated, and I I mean, this is way too broad, I think. Making available includes transmitting, distributing, or selling. So that's, again, fairly broad. Any sort of transmission would count. Minister, I don't care about. We already know who the minister is. Obscene material includes any material, a dominant characteristic of which is the undue exploitation of sex or of sex in any one of or more of the following subjects, namely crime, horror, cruelty, and violence. I think this definition is a little out of date. I think our obscenity laws are probably out of date, and I can do a video on that as well. But regardless, this is basically borrowed from the obscenity sections of the criminal code. Prescribed means prescribed by regulations, so they're going to have regulations later that will change how this works. Sexually explicit material means sexually explicit material as defined for the purpose of subsection 117.1 sub 1 of the criminal code. So let's have a look at what that is. So 117.1 sub 1, every person commits an offense who transmits, makes available, distributes, or sells sexually explicit material to, and there's broad categories here of people under the age of 18, 16, and 14. And these are with respect to doing this for the purpose of facilitating the commission of an offense. So this is really a grooming set of laws. This is not just somebody managed to get access to material. This is, they were doing so in order to make that person susceptible to some other offense. And they have a definition here. So means material that is not child porn, which is interesting because it means that child porn would actually end up being excluded as being considered as sexually explicit material for the purpose of Bill S-203. I don't think they meant to do that, but anyway. And that is a photographic, film, video, or other visual representation, whether or not it was made by electronic or mechanical means, and that shows a person who is engaged in or is depicted as engaged in explicit sexual activity, the dominant characteristic of which is the depiction for a sexual purpose of a person's genital organs or anal region, or if the person is female, her breasts. So not male breasts. All right, fair enough, I guess. Written material whose dominant characteristic is the description for a sexual purpose of explicit sexual activity with a person, or an audio recording whose dominant characteristic is the description, presentation, or representation for a sexual purpose of explicit sexual activity with a person. So a fairly broad set of definitions, and by tying it to that definition, it allows them to essentially borrow any of the prior precedent in terms of interpreting this when we look at Bill S-203. So let's jump back. And young person means anyone who's under the age of 18. So, purpose. The purpose of this act is to protect public health and public safety, and in particular to A, protect the mental health of young persons by restricting their access to sexually explicit material. B, protect Canadians, in particular young persons and women, from the harmful effects of exposure of young persons to sexually explicit material, including demeaning material and material depicting sexual violence. And C, deter anyone who makes sexually explicit material available on the internet for commercial purposes from allowing young persons to access that material. All right, so let's see how it goes about doing this, because the devil is always in the details, right? So offense, making sexually explicit material available to a young person. Every person who, for commercial purposes, makes available sexually explicit material on the internet to a young person is guilty of an offense punishable on summary conviction and is liable. So we don't really have a good definition of for commercial purposes here, but so this is going to end up being something that gets litigated. If you have a site where people share pictures of themselves and they have, and it has ads, is that for a commercial purpose? Does it matter if they're just covering their expenses or, versus making a profit? All of this is, difficult. This could also end up covering people who, for instance, run an OnlyFans or that kind of thing. Somebody who runs an OnlyFans isn't really in control of the age verification. So this is going to end up being used, amongst other things, against sex workers, against people who might be discussing their own sexuality. All of this is a potential free speech nightmare. So in the case of an individual, for a first offense, fine of not more than 10 grand. For a second or subsequent offense, fine of not more than 20 grand or to imprisonment for a term of not more than 6 months, or both. And for a corporation, 250,000 for a first offense, and then $500,000 for a second or subsequent offense. So lots of money. Now, don't necessarily be scared of big numbers when you see this in these bills, because these are maximums. Most people are not going to be looking at maximums, but still, they are not coming out gently on this. They're coming out swinging hard. So liability of officers, directors, etc. If a corporation commits an offense under this act, any director, officer, or agent or mandatory of the corporation who directed, authorized, assented to, acquiesced in, or participated in the commission of the offense is a party to and guilty of it, and liable on conviction to the punishment provided for the offense, whether or not the corporation has been prosecuted or convicted. So they can go after the directors individually, even if they don't go after the company. Offense by employee or agent or mandatory. A person is liable for an offense that is committed by the person's employee or their agent or mandatory who is acting in the course of the employee's employment or within the scope of the agent. So if your employees do something because you told them to, they can go after you. Now here's a critical part. Defense. Age verification. It is not a defense to a charge under Section 4 that the accused believed that the young person referred to in that paragraph was at least 18 years of age, unless the accused implemented a prescribed age verification method to limit access to the sexually explicit material made available for commercial purposes to individuals who are at least 18 years of age. So you can't say, listen, I thought they were 18, unless you used a prescribed method. Now, prescribed, remember, means as they implement in the regulations. So you can't use your own method. You can't develop your own style. You have to use what they specify. This is potentially huge, because if you talk about somebody who, lots of speech online is engaged in for at least partially commercial purposes. This speech here, this is my views. This is, it's important to me that I'm able to communicate with you guys. But there is partially, at least, a commercial purpose. I get some revenue out of this. So this has huge potential implications on speech. And because they say that it must be a prescribed age verification method, well, think of what you can do if you can define the age verification method. You can, for instance, make people submit to some sort of database where you collect who's viewing porn. Is that something you want to trust the government with? I think no, but you may have different takes. Yeah, this is concerning. Defense, legitimate purpose. So no person shall be convicted of an offense under Section 4 if the act that is alleged to constitute the offense has a legitimate purpose related to science, medicine, education, or the arts. Now, I will tell you that lots of people have been prosecuted for obscenity relating to all of those things. And it ends up being incredibly expensive. So saying, hey, listen, I made legitimate art, and, now I got, charged with this, and it cost me 50 grand to defend myself. This defense is not going to be a great comfort to you. So I don't see this as being a great protector of the charter rights that are engaged here. So aggravating circumstance, which means that it makes it worse and the court will impose a greater sentence as a result. So if a person is convicted of an offense under Section 4, the court imposing the sentence on the person must consider as an aggravating circumstance the fact that the material made available for commercial purposes to young persons is obscene material. So that makes it even worse. All right. Notice to internet service providers. Okay, so let's see what we've got here. So if the minister has reasonable grounds to believe that a person has committed the offense referred to in Section 4, the minister may give a notice under this section to any internet service provider, which must identify in a manner that the minister considers appropriate the non-complying person, indicate that the minister has reasonable grounds to believe the person has committed the offense referred to in Section 4, require the internet service provider to take any steps specified in the notice. We'll come back to that. Provide any information that, in the minister's opinion, may assist the internet service provider in complying with any requirement imposed by the notice. Specify the time by which the internet service provider must have complied with any requirement imposed by the notice. inform the internet service provider that non-compliance with any requirement set out in the notice constitutes a violation and is liable to a penalty under Section 10. In the case of a notice other than a notice of a decision to revoke a notice, specify the circumstance in which the minister may revoke the notice and the manner in which the non-compliant person may notify the minister of steps taken to satisfy the minister that the notice ought to be revoked. And H, provide any further particulars that the minister considers appropriate. All right, so what does this mean? Well, it means that the minister will be able to send a notice to your ISP to say this particular web page has to disappear from the internet. Poof. Because that's what they're going to be doing here. Those are going to be the steps specified in the notice, is that the ISP has to block access to that web page, which means that your ISP has to be monitoring your traffic, right? They can't do this if they're not somehow analyzing and assessing your traffic. So this in and of itself includes a surveillance portion, because now your ISP has to watch what you're doing. And also now they have to block you out. This is, this is tremendously concerning because it's requiring the ISPs to create a censorship architecture. Now, if you think that this is not going to be misused, I would like to point you to the entire history of government activity, which is that anytime you give them a broad sweeping power like this, it gets abused. This may get used to target political sites. This may get used to target all sorts of things. The gay and lesbian community has long dealt with obscenity law being used as a weapon against them. The Little Sisters bookstore case, for example, it's literally textbook. That's what was going on. So this is an extremely scary power that the government would be able to tell your ISP, take that site off the internet. Now, keep in mind, this is for legal content, simply because they don't implement some sort of monitoring system, which of course would absolutely breach the privacy of Canadians. Let's look at the next section, which is also kind of terrifying here. Steps specified in the notice may prevent access to other material. So the steps that may be specified under paragraph 2C may include steps that have the effect of preventing persons in Canada from being able to access material other than sexually explicit material when using the service provided by the internet service provider. So let's think about that. Let's say there is a site online that has all old works. Say we'll call it the Gutenberg Library. And let's say some of those works are considered sexually explicit and that they don't have age restriction aspects. They could say, hey, listen, we want you to block that out entirely because it's okay that we're going to cover all of this other stuff just so long as we also get the porn. So this is extremely concerning. Lots of sites that share a variety of content. You might have sites, for instance, that share people's fan fiction. And some of that fan fiction may be sexually explicit. The government can say, well, listen, that sexually explicit content on that fan fiction site, the whole site's got to go. And, the ISP might contact some site which is probably being run in another country and, say, hey, listen, Canada requires that you set up all of this age verification. And that site will probably say, nah, we don't care. So Canadians with this may see sites disappearing off the internet, and it can be quite a bit broader than the sexually explicit material. Huge freedom of expression implications here, just huge. Information provided to users. The notice may require the internet service provider to provide information specified in the notice in a manner specified in the notice to persons in Canada who A, attempt to access the sexually explicit material when using the service provided by the provider, and B, are prevented from doing so as a result of steps taken by the provider that are required by the notice. Which means that when you go to this site, you might get a big thing saying this site is blocked for non-compliance with, Bill S-203. Oh man. So variation and revocation, they can cancel it if they want. They can publish the notice. Now that's a may, not a must, so they don't have to. Administrative monetary penalty. Any internet service provider that fails to comply with any requirements set out in a notice referred to in paragraph 9 sub 2 sub c commits a violation and is liable to a penalty of an amount to be determined in accordance with regulations made under paragraph 11C. So they're going to make regulations to say how bad that's going to cost you. And the purpose of the penalty is to promote compliance with the act and not to punish. Yeah. No, I mean, it's to punish. I don't see how that sentence can make any sense here. So regulations, the governor and council may make regulations for carrying out the purposes and provisions of this act. So they can add additional rules, but it specifies the circumstances in which sexually explicit material is or is not to be regarded as made available for commercial purposes. So they can define that later however they want, including circumstances in which sexually explicit material made available free of charge is or is not to be regarded as made available for commercial purposes. So they could just say commercial purposes is anything you put online. We don't know what they're going to do, but do you think they're going to tailor this narrowly? Nah, this is going to be broad. So prescribing the age verification methods referred to in subsection 7 sub 1. So they can do whatever they want here. They can specify that you personally have to go to a police station and provide your ID and a list of the sites you want to go check. That might be an incredibly intrusive way of doing it, but we don't know what this is going to be. They've said things like, you might have to go to some third-party provider and give them your ID, and then they can give you a code, and then you have to hope and pray that that third-party provider has properly implemented internet security, because I can guarantee you that every ransomware, jackass on the internet is going to view that as an incredibly rich target. Because not only could they go and hit that place for ransomware, but then they have the threat of releasing that information, which of course would be very damaging to that company, or they could just simply steal all that information and then go to everyone who's in that database and extort them. So yeah, this is real concerning. C, fixing a penalty or range of penalties for a violation referred to in section 10 sub 1. So they can pick what the penalties are. Coming into force, so when this actually hits is first anniversary of the day on which it receives royal assent. So there's a year delay between when it gets passed and when it comes into effect. Yeah, this is extremely concerning. This is the government saying, won't somebody please think of the children and let us censor the internet and let us force your ISP to monitor what you're doing and let us decide what content is and is not okay. And knock content off the internet, not because it's necessarily sexually explicit, but because it might be near content that's sexually explicit. Oh man, the charter issues on this are huge. This is going to be, there will be literally millions of dollars worth of litigation on this as soon as it rolls out, because of course there will be fights over this, and the impact on just the internet is concerning. The other thing is that once this sort of architecture gets created, they're going to want to expand what they use it for. So they're going to start with porn, but then they might move on and say, hey, we want to cover this other kind of speech. And oh yeah, now we want to cover this other stuff on the internet. It's concerning that this creates the architecture necessary for something akin to the Great Firewall of China. And Trudeau has made some past comments about China and their basic dictatorship. So this is all very worrying. I will note as well that this was implemented by Senator Julie Miville-Deschênes, who was appointed in 2018 by Justin Trudeau. So all of this is a worry. Anyway, just something I wanted to bring to your attention. So thank you for watching. Please like this video. Please share it with your friends. Please subscribe to see more content. I also want to thank my Patreon supporters. There's a link if you want to join them. At the $50 level, Sir Daniel Wicks of Alberta, Jason Elliott, Canada's National Firearms Association, Kyle Martin, Jean-Guy Toussaint, Ivo Nedev, the CCFR, BCAMF.org, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Matt Ward, Mark Whittington, Dale Nesbitt, Cameron Johnson, Andrew Elsich, and Adam Meester. I also want to thank everyone at the $10 level who will be in the crawl immediately following. Thank you for watching, and I hope this has armed you with knowledge.